All right, would y'all like to approach, please?
Here's some. So hard to touch this with the fingerprint.
Ruby, are you ready?
Yes, sir.
Court calls CR 244666F and CR 226112C, the state of Texas versus Cade Michael Tucker. Can counsel please make their announcements for the record?
Yes, Judge. Cassidy Story for the state.
Jackson Nikorsky for Mr. Tucker.
Leslie Edgersburg on behalf of the defense.
And are you the same Cade Michael Tucker who in CR 226112C is charged with sexual assault and in CR 244666F is charged with unlawful restraint exposure to serious bodily injury?
Yes, Your Honor.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your arm down. The sexual assault case that is pending and for which we were in the middle of trial is a second-degree felony. State, what is the range of punishment for that charge?
Range of punishment is 2 to 20 years in the Texas Department of Criminal Justice or probation if eligible.
And up to a $10,000 fine.
Correct.
Do you understand that that is the range of punishment for that charge?
Yes, Your Honor.
In the unlawful restraint, exposure to serious bodily injury, that's a third-degree felony. State, what is the range of punishment for that charge?
2 to 10 years in the Texas Department of Criminal Justice and up to a $10,000 fine.
Do you understand that's the range of punishment for that charge?
Yes, Your Honor.
I have paperwork here that indicates you would like to enter into a plea bargain agreement in the unlawful restraint exposure to SBI. I'm showing you what is the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorneys and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes, Your Honor.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, Your Honor.
And is this your signature on the final page?
Yes, Your Honor.
Now, for this unlawful restraint charge exposure to SBI, you have, this is filed by a new information. Have you discussed what that means with your attorney?
Yes, Your Honor.
And it means that you would, among other things, have up to 10 days before you could be required to do anything in this case. Do you want to waive that 10 days and proceed with this plea bargain agreement?
Yes, Your Honor.
Okay. You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during this trial. You have the right to have your attorneys cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, you still wish to proceed with this plea agreement.
Yes, Your Honor.
Understand that this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow the agreement, I will allow you to withdraw your plea and you can proceed as if this doesn't happen. This didn't happen. Do you understand?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, I am.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under in accordance with Article 3914. Are you satisfied that the state fulfilled that obligation?
I am satisfied, Your Honor.
And do you believe that your client is competent to enter into this plea today?
Yes, Your Honor. I've spoken with Mr. Tucker numerous times over the past 3 years, and I do believe he's competent.
Mr. Tucker, the reason that we talk about the evidence is because you have the right to know what the evidence is against you. Did you discuss that with your attorney?
Yes, Your Honor.
And are you satisfied that your attorneys provided you with effective assistance of counsel during the course of this case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty to unlawful restraint, exposure to serious bodily injury, the state will recommend 10 years in the Texas Department of Criminal Justice. That would be suspended for 6 years. There will be restitution, supervision fee, an evaluation, community service restitution, which could include the adoption or the fostering of an animal from the animal shelter, and you will have no contact with the victim and be in the sex offender caseload. Is that your understanding of the agreement?
What did you say about the confinement one?
So you are the time here is 10 years in the Texas Department of Criminal Justice. That will be suspended for 6 years. So your underlining is you will be convicted of this case and your sentence will be for 10 years. However, that sentence will be suspended, which means you do not serve that time.
Just wanted to make sure.
If you complete your conditions satisfactorily, you may and likely will never have to serve that time. If not, 10 years would be what the range of punishment, up to 10 years would be what you would face.
Okay.
All
I
right.
understand now.
Okay. So understanding that complete agreement that I went over, would you like to enter into that plea agreement now?
Yes, Your Honor.
To the charge of unlawful restraint, exposure to serious bodily injury, how do you plead?
Guilty?
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
State, have you given notice to the victim of this proposed resolution?
Yes, Your Honor.
What state do you believe of the evidence that the court has heard shows that the Jane Doe was exposed to a substantial risk of serious bodily injury?
Your Honor, based on the testimony that we've heard, the allegations are that the defendant held Jane Doe down by both of her legs as well as her arms and put significant pressure with her wrist to her back, as well as banged her head against the wall several times while performing sexual intercourse. Under this, Your Honor, I believe that is a substantial risk of serious bodily injury that could have occurred at that time. Your Honor, there is also other evidence to support vaginal tearing that is within the same exam.
But that evidence isn't before the court.
No, Your Honor.
Okay. Based on your plea of guilty, based on stipulation evidence, and based on the evidence that the court has heard during the course of this trial in CR 2261-12C, court accepts your plea bargain agreement and finds that you are guilty. However, I'm not going to sentence you at this time. What I will do is order a PSI. Someone from probation will come and speak to you. They'll make a report. When that report is ready, they'll bring it back to court and you will be sentenced at that time. You understand that the person who will sentence you is not this court. It's not this judge, it will be someone else. And because it is someone else, so long as they follow your plea bargain agreement, you also will not have a right of appeal. Does that make sense?
Yes, Your Honor.
So don't be surprised when someone else is sitting here and is sentencing you on this case.
Yes, Your Honor.
Understood? All right. Is there any?
Judge, the state would request that he be sentenced today and set for a status hearing to address any conditions on his probation that are outstanding based on the recommendation of the probation department after evaluation. However, the majority of the conditions have been agreed upon between the defense and the state. The victim is present, would like to give an allocution. And in the interest of judicial economy, the fact that we have a jury that's out on a charge that would be dismissed subsequent to this plea, I would ask the court to go ahead and sentence today.
Already heard?
We are in agreement with the state's request, Your Honor. Additionally, if it matters at all, Mr. Tucker is a resident of Harris County, so we could have him sentenced today and then begin the probation intake process and perhaps get that transferred to Harris County. That would streamline things.
Okay. Well, I mean, they're going to have to do, ultimately, he's going to have to come out back here for the PSI and you're going to have to come back for the sentencing because that judge will give the final conditions. So, I mean, that seems unique too, because it would be a different judge who is finalizing the sentence. And that concerns me a little bit, that that judge would be tied into what I did, despite the fact that I'm not going to.
So I,
Would you say it ties the hands of the new judge?
in the way that her hands would be tied on any case where you had placed someone on probation previously or supervision previously.
Would it be possible, Your Honor, in this particular matter, there have been certain times where conditions have been agreed on by the state and defense and a PSI is waived?
No, we're not gonna waive PSI because I want to hear from, well, I assume the new judge will want to hear from the, whatever. Any legal reason can't be sentenced at this time?
No, Your Honor.
Any legal reason?
Your Honor.
Court sentences you to 10 years in Texas Department of Criminal Justice. That will be suspended for 6 years. There will be no fine. You will pay restitution in the amount of $2,128. There will be a community supervision fee of $60. You'll do the evaluation that probation will handle, and you will do 300 hours of community service restitution. You'll have no contact with the victim. You know who that person is, right?
Yes, Your Honor.
We've called her under different names, but realize you know who it is. Do not have contact of any sort, really, directly or indirectly. And you will be part of the sex offender caseload, although that doesn't mean necessarily that you will have the sex offender restrictions.
Yes, Your Honor.
Judge, I believe you on the record, you said 300 hours, but my understanding is the agreement is 250 hours of community service.
So I changed it to 300 because I'm doing 50 per year. All right, but if you want to withdraw the plea because of that,
No, Judge,
you're welcome to.
thank you. No.
All right. Okay, well, what's going to happen in the sexual assault charge?
It will be dismissed, Your Honor, and I have tendered a dismissal to the court.
Very good, accept it. Sir, the CR 2261-12C sexual assault is the dismissal filed by the state is signed. So all of the conditions that you were under for that charge are now lifted. And the only case that remains active is CR 2446-66F. Is there anything else we need to take up?
No, Your Honor, not at this time.
Will the complaining witness in this new case be due come back at a later date for allocution then?
No, she is present now that he has been sentenced. She's walking up the stairs as we speak, but I know judge wants to not waste the jury's time, so.
Okay.
So
what
we
we'll
do still
do-
have allocution, but we'll do that after the jury's released.
Yes.
Yep, okay. Anything else we need to take up, Joe?
No.
No, Your Honor.
All right, sir, I must let you know that because this is a felony, you are ineligible. Do you have the paperwork for me for the ineligibility to have a firearm or ammunition?
Is it not part of that?
I know we signed it.
Do you understand that?
Yeah.
Yes, Your Honor.
Are you still in the military?
I am not, Your Honor.
All right. In addition, since I have sentenced you, you do not have a right of appeal. I'm signing the trial court certification. That will be added to your file and you can, and you do not have a right of appeal.
Yes, Your Honor.
Anything else?
No, thank
All
you,
right,
Your Honor.
good luck to you, sir.
Thank you, sir.
You line them up and bring them in, please?
Judge, can I approach you?
Yes.
So my understanding is that he places probation service
He is as of today.
as of today.
Yes.
Correct. Moving on, he gave his condition prepared, because there's gonna be a plea, at least at the case off.
Okay,
But since what transpired, the conditions and conditions will in your office hopefully by tomorrow.
Okay.
This afternoon. The only thing, and I spoke to the salary, is regarding our recommendation of the plea already have those sex offender conditions. If for some reason probation doesn't, the probation doesn't serve as a offense or anything like that. Stay out of those areas.
so you'll have to do the evaluation still?
Yes, sir. Yeah, we still have the whole 9 yards.
Yeah. Right, and then they'll just come back and do a status hearing.
No, so you don't, there's gonna be a separate status. Yes. Okay. If any change
Where any conditions will be done at that time. But if there are conditions to start it now, we can do that.
I mean, for sure, the sex offender condition, the sex offender case of the conditions will be implemented after this day.
Okay.
But anything extra, I guess, will be either added or discussed.
Okay.
Okay. When is?
Sure, that's fine.
Yeah.
She has the date there. Yes, please.
I am not staying allocution, so I just want to say.
It was a pleasure.
It was a
It's so
pleasure.
nice to meet you.
You too.
I was very impressed with your professionalism,
You.
and going up to the line, but not as we're crossing it. It would be so wonderful if everyone did it that way.
Thank you.
And all of how you handled yourself was wonderful.
Appreciate you.
And look, I appreciate you too on this. You know, when I told you it will be up now,
Mhm.
and you wanted to go back and look at it.
Yeah.
The amount of grief that I got on that was incredible. And so you coming in and saying like, oh no, I'll see you.
Appreciate that, yeah.
So,
And I noticed you bring in students often for your
so
cases.
well, I taught over at the university. So I taught the last 3 semesters.
Okay.
Not teaching right now, to be very clear.
Mhm. Yeah.
But they come in a
I
lot.
think that's great.
How it transforms their
Absolutely.
understanding of how everything works.
I appreciate it.
And I like them. I like saying, yeah,
It's
good.
Nice meeting you.
Nice meeting you.
Bye.
Thank you. Take care. Nice to meet you too. Bye-bye.
Yes.
It's out all the way from there.
Yeah, because they're gonna do the full.
Take care. Thank you.
Yeah.
Thank you so much. Thank you. Thank you.
And did you just call it a status?
Yes, I changed it.
Okay.
I asked them.
Yes.
All rise for the jury.
You may be seated. All right, well, thank you very much for your patience. During the time that you have been out, the parties have reached an agreement and they have pleaded in this case. That means that your time as jurors is now over. All of the restrictions that I gave to you have been lifted and you are able to talk to anyone that you would like to. And that may include the attorneys. Oftentimes the attorneys like to come back afterwards and ask you what was important to you, what you saw in the evidence, what they might could do better. These attorneys will be trying other cases like this on behalf of the community and on behalf of a defendant. And so it's helpful to them. It does not mean that you have to talk to them, but know that the restrictions that I give to you are lifted and you are able to if you want to. Let me also thank you. Although we did not reach a verdict in this case, that doesn't mean that it wasn't absolutely important what you've done. This case has been waiting around, as you've seen. There was a date of November 2020 was when the allegation occurred. November 2022 was when it was indicted. And so there has been a period of time that we needed to get this case taken care of. And we could only do that because you came in and were willing to serve as jurors. I appreciate that very much. All the things that I say to you about the importance of jury trials, about what you do to govern your community, I mean from the bottom of my heart. And so I appreciate you very much for being here. I'll come back and just tell you thank you briefly, but you are all free to go about your business. Thank you very much.
All rise for the jury.
Anything else we need to take up in this case?
From the state, Robert.
All right, thank you both. Good job.